All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Robert Campbell. Here. Michael Chitty. Michael Wilborn Chitty. Paul Fairchild. Paul William Fairchild. Stephanie Goss. Stephanie Goss. Rebecca Hunter. Matthew Kearns. Louise Leha. Tanya McBride. Amber Morpus. James O'Brien. Douglas Panigua. Douglas Panigua. Paniagua. I do the best that I can on that, so I think I've given notes as best I can. Yes, she gave best I can. David Reed. Lonnie Roberts. Xavier Williams. Jake Wilson. Tavares Dixon. Valdemar Salinas. James Godwin. Joshua Chanel. Emmett Lambert. Emmett Leon Lambert.
Judge, I understand the conversation on the case. I will check with the state and see if you have it on file.
My docket has written in plea. That's different.
Your Honor, I know there was some discussion between Ms. Curry and Mr. Manning about a dismissal. I'm afraid I just don't know what the specifics are on that. But I know there was a discussion about that.
Okay. Jeremy Lowe.
Here.
Benny McFarland.
Here.
Alfonso Perez. Shakol Sampson. Bobby Shaw. Eric Sperling. Tanya Swart. Kenneth Warrington. Jeremy Snelson.
Judge, he's on the play.
You just having car troubles? You just didn't.
Yeah, I think we lived with our DC probably needed to get through.
It's gonna be a plea today.
Oh, that,
Sure, it's not gonna be a plea today.
I'm sure.
All right. Louise. Okay, let's see. Louise Funes Rivera. There was a waiver of arraignment. It's been accepted. Pre-trial set October 24th. We'll take that one off. Same announcement on, let's see, Lesky Rodriguez Miranda. Arraignment waiver filed October 24th. John Dunlap. Tiffany Light. Lisa Cabernet. Tracy Jacobs. Brandon McClanahan. Wendy Price. That's going to be believe. Thank you, Ms. White. Simon Wilkes. Here. That's also going to be. Sir. All right. Anyone's name that I've not called. All right, we have counsel that's ready. Roberts. Mr. Godwin, if you'll come forward, CR 23-140 and 141. Godwin sitting on pre-trial.
You're not to ask for a pass if I could. I had a issue with my discovery portal, but I've since been able to access it. And I started downloading Discovery today and I just have not had a chance to review it. So I'd ask for one pass if we could to where I enable myself to be able to review Discovery in this matter.
Any objection from the state?
I'm sorry, Your Honor.
Any objection from the state requesting for additional pretrial?
No, Your Honor.
And what's the issue with the discovery portal? Is something that the state's got to resolve, or you?
It's been resolved, Your Honor. It was, at one point, it was, apparently it was discontinued. I don't know. And, but it's back on. So I didn't get notice it's back on, but I checked just to make sure today and then it's there. So I started downloading the materials today.
What about October 24th?
Okay, that's gonna be fine. Sure. It's a good thing.
All right, Mr. Godwin, we'll see you back October 24th at 9 a.m. Pre-trial.
Thank you, Your Honor. Is that gonna be at 9 o'clock, Your Honor?
Yes, sir. Other council that's ready. One has swear on her. And July. Tiffany Light. CR 2259. So there were some pre-trial today.
Your Honor, I filed my normal 3 motions. I don't believe the state has any opposition, but as of right now, I do not have the DVDs. I checked on Friday and on Tuesday, and they were not in my box. And I don't know if they're gonna be able to stream those to me or not, if we could have another.
Do you have any update on that, Mr. Crowley?
I can check right now, Your Honor. I didn't know that the DVDs weren't there, but I can see if they are now.
While we're looking that up, Ms. Like, have you signed your conditions of pre-trial release paperwork? Have you done that yet?
I
She does.
I don't believe she probably has had that opportunity. This is the first time we've appeared in court.
Your Honor, it looks like there are discs ready, although they may not have been in Mr. White's box. Looks like we copied them back at the inception of the case in 2020. So they just might not have been in the box at that point.
All right, court's gonna reset and select the additional pre-trial available on October 24th. Mr. White.
Is that a Tuesday or Thursday? Tuesday. Okay. Let me check this real quick. I think it'll have to be the 24th. I got a doctor's appointment 26th, so.
Okay. All right, we'll set this like pre-trial October 24th at 9 a.m. Ms. White, you had posted bail in this case. The court's going to place conditions on you for you to report, drug test, follow some other requirements of the court. If you violate any of those, the court could revoke or bail, put you back in jail, okay? So I want you to meet with the pre-trial release officer before you leave today, and they'll have that paperwork for you. Mr. White can answer any questions, as well as the pre-trial release officer, okay? Just make sure you sign that before you leave.
Your Honor, we'll wait.
Mr. Dunlap. You need to step outside, make some water or something, go ahead and do that. Matthew Kearns. All right, this is sanctions court hearing for Matthew John Kearns, CR 2324. Mr. Kearns, I see that you completed all your community service hours. Sheriff Larry Smith. Correct? All right, it's the recommendation from the probation department that we release you from sanctions court, so. While Brandon's back here, let you get back on probation and finish up doing the rest of your stuff, okay? Thank you, sir. Jake Wilson. Sanctions court hearing. I think I gave you three things to do. Paid your probation, you paid your collections, asked you to do 15 hours community service, you did 32. Okay, good work. What I'm gonna do is I'm gonna reset you to October 24th. And same thing, 125 on probation, 75 in collections. Minimum 15 hours community service. If you do more, great, and that'll get you ahead. Okay, so good job on all of that. Get you reset, get you out. Okay. It's a Tuesday or a Thursday, doesn't matter, if you want better, then yeah, okay, doesn't matter. Like this. All right, I'm gonna sign this, and then you get your copy ready to go. Finding your right. Those sanctions court hearing. All right, Tanya, for a while now, you've been hitting all your marks, doing what you need to be doing. So I'm very pleased to see that. You still, still have big restitution we're working on, we know that. So I want you to remember, we're looking for that same 325 probation, 25 in court, 10 hours community services. Keep doing what you're doing, okay? I'm gonna release you from sanctions court because I think you're gonna get back on the straight and narrow, and I trust that when I put you back in the probation department, they won't send you back over here. Okay? All right. I'm not gonna say see you soon. All right, have a good day. Is Paul Fairchild here? James O'Brien. All right, Mr. O'Brien, you've complied with all of your sanctions, your payments, probation, your court collections, you've done your community service. If we can keep this up for a couple of months, then I'm going to probably release you from sanctions court, okay? But I need to see a couple more months of compliance, okay? So I'm gonna bring you back on October 24th, same thing, 65 probation, 64, 10 hours community service. Once you kind of make that a habit, so you get out of sanctions court, before you know it, you'll be done with your community service, okay? All right, next time, so I give it. David Reed. All right, Mr. Reed, so, you've complied, with everything we talked about last time, your payments, your community service, where you doing your community service at?
Harrisburg, Edgewood.
Bridgeburg, good.
I just did 10 hours this past Saturday too. It's not on there, so.
Good, excellent. All right, well, getting ahead,
Yes,
that's
sir.
wrong with getting ahead. All right, so I'm gonna bring you back on October 24th. And we're gonna do the same thing, 65 probation, 65 collections, 10 hours of community service. Minimum, you do more, that's great. And if you can show me 2, 3, 4 months of consistent compliance, then I'll just let you back on probation. And save you a day.
Thank you, sir.
All
Appreciate
right, let's sign this form right here. Your reset date. Lonnie Roberts. Thanks, Your Honor. You're welcome. Thank you, sir. All right, Mr. Roberts, same for you. You paid your probation, you paid your court collections, you did your 10 hours. Where you doing your community service? First Monday. First Monday? Okay. All right, same thing. I'm gonna bring you back into October 24th. I want you to make the same goals we had last time, okay? 65, 40, and 10. Written that on here. So I want you to sign this, and we'll see you back. Show me a few months of doing this consistently. And I'll take my thumb off and be able to let you back to start regular probation, okay?
Thanks, sir.
Adams, are you ready?
Oh.
You need some time. Are you ready, sir?
I'm ready, Judge.
And Your Honor, may we approach?
You may.
Okay, you over there too.
This is cause number CR 19-291, state versus Waldemar Salinas, set for hearing on social code. Court is going to have a request of defense and agreement by the state. Court's going to set Mr. Salinas' next hearing on November 30th at 9 AM. Mr. Salinas, you're still on community supervision. If just the motion's been filed, that you don't have to report or pay or protest or do all those things. Okay, I understand, keep on reporting and doing those things. And we'll see you back on November 30th. Okay, so I mean, I'm giving you some time here, so October, you need to report. I don't want to hear, I didn't report in October because I was coming back for November. You're still on regular probation. Good. Thank you. All right, we'll see y'all back on this.
Thank you. You too.
Rebecca Huntry. All right, Ms. Hunter, let's see. Don't show that you complied with anything we talked about in court. No community service, didn't pay your court collections, didn't pay your probation fees.
I'm sorry, Your Honor. I thought I was supposed to bring the money was here today. I brought those.
So you have your $65 to probation, $65 to court.
I got a treat. I got my job.
What about your community service? Did you do this?
I'm working in a hot warehouse, and by the time I get off, I'm just exhausted. I work 6 days a week. It's not an excuse, I know, but money, and I got a horse to keep me busy, so I rest.
Looks like you got on probation in August of last year. And you have 360 hours of community service. You expire in 2027. Further, you push your community service back, the more likely you're not going to complete on time, and that's why you're here. So what's your plan on how to do community service?
I'm working on getting my car right. It's hard to get rides to work. Right now. And I'm not used to working in a hot warehouse. I'm getting it. Like I'm also on probation in Smith County, so fines for them right now. And I'm also paying them on.
Are you behind with them?
This, I had maybe, I got on sanctions for and compliance at the same time. I know I've been on a year and I had to make progress, but it's like my trauma therapist said it took me a long time to do my stuff. On trial.
Are you behind on your community service in Smith County? How far behind on that?
Probably the same.
So what do you propose I do?
I'm thankful for being on probation because I've never really gotten as far as I guess working. I've been clean. I haven't felt one drug test in either county. I have my dream job. Like I know I need to do more. I know that, but I am getting it.
So what I'm gonna do is I'm gonna bring you back on October 24th, okay? And I'm going to, you gotta pay 60, you said you brought your money today, so I want, on that date, I need another $65 to probation, $65 to court. And I'm gonna lower it to 10 hours of community service. For every one of those that you don't do, it's gonna be a day in jail. Okay, so if you come back and you say, I was hot, I was tired, and I didn't do my community service, then you're gonna go to jail for the day. And the bad thing about that is that community service will be waiting on you when you get out. It's not like you discharge it, it's not like you get 10 hours credit on community service, right? So swallow, no credit, okay? So I'm not trying to make it hard on you, but I am trying to get you to where you can get back on probation without me having to monitor you all the time. And that you can get caught up and expire on time. But if you don't, then I know that in these type of circumstances, when stress and pressure get put on people, sometimes they revert to old habits, and that's not what I want. I don't want you to look up and at the end of your last year of probation, you have 300 something hours of service because you haven't done it. Then you're gonna freak out about having to be ordered, about being put in jail. You're gonna relapse. You're gonna, all this is gonna go away. And there's a rehab.
Like that right now. It combines with both court, because I know that I'm doing a lot of.
And what I'm looking for is the effort. That's why I lowered it to 24 hours to 10. I wanna see the effort. You show me that you're trying and all these things that you told me about saying. Those counties, that's good. That's what I want to hear. That's the main, okay? We can work with money, work with community service. We're not gonna revoke you and send you to prison for those things. Okay, you work very hard not to do that. You're gonna have to put the hammer down on your side. And I know if you work long, hard hours, hot, you're tired, I understand it, but in circumstances, you kind of find yourself. in. So that's part of having to work through those, to get back. It's part of paying your debts to society for your crime. Okay, feel me? Okay. All right, let me plus a reset down here.
Question, what about paying for restitution? Is that?
Said, you'll pay that as probation, your fines, over here across the hall, and your 40 fees in your restitution. And probation. So you're gonna pay those today when you leave, right? All right, so before I let you go, so I'll make sure that we're clear. So $65 in probation, you don't do that. On the October 24th, and that's gonna be a day in jail.
Yeah.
65 on your court collection, if you don't do that, it's a day in jail. 10 hours community service, you don't do the 10 hours, that's a day in jail. Okay, so if you pay your money, don't do your community service. They don't, got it,
It's still there to mark it out.
it's still there, do that. All right. Keep working hard. Please lay off. All right, Mr. Whitehall, this is your first time in sanctions court, correct? You know what sanctions court, do you know what the goal of sanctions court is, why we do this program?
To try to get you back on track.
That's right, that's good. And what's going off track? What does going off track mean?
Basically getting back in compliance with
Yeah, where does non-compliance lead you?
to jail.
Back to jail. In your case, you were on deferred adjudication, so you haven't been found guilty, which is a blessing. Trust me, how old are you?
25.
25, you're a young man. It would suck to live the rest of your life with a felony conviction. You know what that would do to your life? You really? What would it do? Give me some
It
examples.
would like mess with my jobs, anything, basically.
Yeah. Would definitely change the type of living you can make for yourself. And your inability to work is going to affect every other facet of your life, of your relationships. You have kids, you have kids yet? You have kids later in life, it's going to affect their life. It affects everything because work is part of our pattern of being, right? So it can have a very detrimental effect, but you don't have to face that yet because you're on deferred or a second degree felony. Remind me what the range of punishment is for a second degree felony.
2 to 20 years.
2 to 20, so you're paying attention. So if you violate, you come back for hearing, you could be sent to prison from the minimum 2 up to that maximum 20. It's not what you want to do, is it? And had you ever been in jail prior to this arrest? This is the first time you've ever gotten in trouble. And it's almost the maximum. You're on what, 6 6 years for probation? Something like that? Actually, you were on 4 and you got extended, right?
Yes, sir.
Yeah, you got on in 2017. It's a long time ago. So you're set to expire now in like 2027. Really behind on your community service. Is there a reason that you can't go 1 weekend a month and work 1 Saturday at a,
That's what I'm trying to clear out. So it's the transportation at the moment,
you have family members
not where I live.
where you live?
By myself in Dallas.
Dallas. You got 2 legs,
Yes, sir.
and you walk,
Yes, sir.
get up early, go wherever you gotta go, donate your time for stay out of jail. I mean, doesn't that seem to be worth it?
Yes, sir.
It's not, it's only as hard as you make it. It'd be different if you kind of rolling up here in a wheelchair with an oxygen tank, an emphysema or COPD. You tell me that you can't do community service, that's one thing, but you're a healthy young man. So, and if you're in Dallas, there's a lot of opportunities there. You were assessed 400 hours. You've already done some community service. You've worked 147. So at one time you were doing it. Is there a reason that you
It
fell
was,
out of it?
it was easier for me, I guess, because it was donate. So, yeah, that's why it was kind of easier for me because I just had to go to the bank. Now that I actually have, like, I work from 7 a.m. to 5 p.m. In the weekends, it's rarely open for like any community service hours. So I work Monday through Friday.
Well, you might have to find a soup kitchen or something that you can go at night, the shelter or something where you can go at night and you might not be able to do all yours one day. You might have to do it every other day for 2 or 3 hours.
Yes.
Okay. This has to be a priority for you. Has to. So no one, including me, wants to see you get convicted, have a felony of offense on your record or community service. That doesn't make sense. Okay.
Yes, sir.
So I need you to buckle down, man up, figure out how you're gonna get this done. So what I'm gonna do, you go by Louise or what do you go by?
Yes.
Louise. So I'm gonna bring you back in October, right? So I'm gonna give you some of these goals and if you don't meet them, then we're gonna have a different conversation about sanctions. Okay. If you can meet these goals every month, then after maybe 3 or 4 months, me seeing that you are back on track, I'll let you out of sanctions court. Save you a day, you might come down here and mess with all this.
Sounds perfect.
All right, yes, let me fill out this reset form. And so there's a couple things I need. So one of the sanctions, I need you to pay $200 to probation by October 24th. Okay, and I need you to work 15 hours community service. All right, so today's the 21st, so you're gonna have more than 30 days to get that done. Don't wait till last week, and it needs to be turned in before you come to court.
Yes, sir.
Okay, it needs to be turned in before you come to court. And I want you to take a UA today. Okay. Do you have a list of places from the Dallas County Probation Department?
I'll get with my probation officer in Dallas. She's usually very helpful with those stuff.
They give you a head start on where to look, where to go.
Yeah, I like it.
With your schedule.
Yes, sir.
All right, so I'm gonna have you sign this form, so we're gonna come back October 24th. That's what I expect, 15 hours community service, $200 payment to your probation. And we're gonna UA you today. Okay.
Sounds perfect. Thank you very much.
Douglas Panyaka here. Great, sir. Tavares Dixon. CR 21-11. So, status.
Yes, Your Honor. For the record, Mitch Adams, on behalf of Mr. Dixon. Your Honor, this is an older case. We actually had a plea agreement worked out with the district attorney's office a year ago. The thumbnail sketch of that plea agreement is that in exchange for his plea of guilty to the lesser included misdemeanor offense of possession of marijuana, state would agree to recommend that Mr. Dixon be sentenced to serve 2 days in county jail with credit for time served. Now, Mr. Dixon lives in Rapides Parish, and we were scheduled or had arranged for our plea hearing for purposes of the plea hearing for Mr. Dixon to appear remotely by video. Mr. Dixon encountered some problems and in accessing the link, he made a phone call. He got a hold of someone here at the courthouse who told him satisfied financial conditions, you don't need to worry about anything else. Well, that was not quite accurate. I've got a smoking gun in my file to substantiate that. A warrant was issued for Mr. Dixon's arrest. He was arrested on that warrant in East Baton Rouge Parish, was extradited to back here to Van Zandt County, and spent an additional couple of 3 weeks in county jail here before he was able to bond out. I've confirmed with Mr. Hartwell that the plea offer is still in place. We would like to have this case set for a plea hearing so that we can consummate our agreement. Mr. Dixon would much prefer to come back and appear in person for that rather than make an attempt at a video appearance again. And so we'd ask the court to set us for a plea hearing at some point, sometime in October.
Got a couple dates available, Mr. Adams. Got the 10th, 12th, 24th.
Already here on those days. I guess October 10th. Be the preferred date.
There'll be a time served, Mr. Mayor.
Yes, sir.
Mr. Dixon, you've got, I recall one time, on one of your previous hearings, you were experiencing car trouble. Are we good on transportation, everything? Yeah. Am I right about that? You were experiencing car trouble one time? Okay, that's what I thought I recalled. Okay, all right, cool. We set Mr. Dixon then to enter his plea on October 10th at 9 a.m.
That's all I have this morning, Your Honor.
All right, so next is free to go. Can I talk to you real quick? Right, this is cause number CR 20-70, say versus Xavier Tayshawn Williams. Mr. Williams, it's my understanding that you have retained an attorney to represent you on the motion or vote, Mr. Tad Walhorn. He was in contact with the court yesterday, indicated that he was in federal court today, he was unable to make it. So I'm gonna reset your case so that he can be here, okay? Yes, sir. I'm gonna reset you to October. October 10th. Okay, it's a couple of weeks. So sign this notice right here and then you'll be free to go. Make sure you contact all this and let him know about that reset date, okay? Yes, sir. We're gonna send it to you, but it'd be good to hear from you as well. Pretty good. You're welcome. Why? You haven't shut it.
We just received them, Your Honor. I'm just working on stipulating on it this time.
All right, I guess I'm gonna stand in recess. Paperwork. Of course, we're gonna stand in recess for 20 minutes, 10:15, so I'll resume about 10:35. Pardon, Mr. Manning, please, ready?
Been ready on this, support.
Swart, would you come forward, please? File number CR 3143. So that she said the pre-trial, go ahead.
Yes, Judge. At this point in time, there's no disciplinary trial issues. We request to be set on Docket call. Judge, I wouldn't make a note, though. I represent both Smith Swart and one of the co-defendants. There may be a conflict.
Just give me a second.
There may be a conflict. However, I've been unable to get a hold of the co-defendant in the case as he has a warrant out for his arrest. So we request to be set on Docket call just pending that one issue.
All right, we'll set Swart for docket call. October. Says to September 9th.
Judge, what date?
I'm sorry, November 9th. November 9th. It's worth, just go that other way. Y'all don't need to be coming to there. It's okay.
Judge, ready on Mr. Joshua Chenault.
Mr. Chenault. Problem number CR 23-8, Dr. Cole.
Yes, Judge. I believe this is our first setting for docket call. I've had a couple appointments scheduled with Mr. Chenault. He's been unable to make to go over discovery and discuss defenses in this case. He discussed some items with me today that I would like to discuss with the state as possible defenses or mitigation to be able to resolve his case. We request an additional docket call. Additionally, Mr. Chenault has notified me that he would request time to hire an attorney. I told him that he could get an attorney at any point in time, just to make sure that he lets the court and myself know, so I can stop work on this case.
About October 12th.
Judge, let me check.
3 weeks.
Judge, October 12th.
Court sets Mr. Chenault for October 12th at 9. Next.
Mr. Bobby Shaw.
CR 23-118, pre-trial.
Yes, Judge. Mr. Shaw set up for pretrial. My understanding was that several of his pending cases were taken to grand jury at the last grand jury.
I think we intended to, but we didn't get them to grand jury this time. So.
Okay, so we're currently pending a couple other cases. I was told last discussion they were going to be indicted. Obviously, that's not happening, guys. We requested we just wait on the pretrial to get all of those cases. Some of them are related, some of them are unrelated.
To the pre-trial issues in this case, or is it just about negotiation?
It's mainly about negotiation, keeping all of it together. Some of the cases will be, I anticipated we're unable to get a resolution. We're going to be setting for trial pretty quickly, based on the discussion.
You anticipate when Mr. Shaw's cases may go to grand jury?
Your Honor, I just see that they're assigned as attorney review. They haven't been assigned to me, so I haven't looked at them. I expect they should be ready for the next grand jury. But I couldn't give the court a definite answer with that. I don't know if if there's more information being sought or where it's at in the review process.
These are not new cases that have originated here.
No, Judge. No, these cases actually predated the case that was indicted.
Right, of course, got sent to Shaw, initial pretrial on November 9th. Next,
Mr. Alfonso Perez Jr.
Perez. Zero 23-7 for pretrial.
Yes, Judge. I was able to provide a counteroffer to the state's offer today. And I would request that we set for the November date for my clients to consider, to consider the counteroffer on my client to prepare. He's trying to get some money saved up so he can get a good start on probation.
Any contested pretrial motion?
None at this time, Judge.
All right, there being no contested pretrial motions, court sets Mr. Perez for docket call on November 9th. 9 a.m. Ready to go. Next.
Judge, we have the paperwork on Mr. Warrington. Approach.
Yes, Kenneth Warrington, CR 22-257.
That's fine.
It's a waiver of indictment to the information. Judgment says the information.
No, Judge, this was indicted.
All right, so we're gonna need to correct the front page here. So it's charging information.
Yes.
All right, Mr. Warrington, if you'll raise your right hand, sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God. This is cause number CR 22-257. Mr. Warrington, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. John. Are you pleased with Mr. Meany? Work has done for you? Feel like you've had enough time to talk with him about your case, that you've had all your legal questions answered, and you understand everything that you've read and signed here today. Mr. Manning, do you believe your client to be competent? If so, you believe that he is entering this plea agreement intentionally, knowingly, and voluntarily?
He is competent and he is entering in this plea freely, knowingly, intentionally, and voluntarily.
Thank you, Mr. Manning. All right, Mr. Warrington, you are indicted with the third-degree felony offense of possession of a controlled substance, penalty group 1, greater than or equal to 1 gram, less than 4 grams. That does carry a range of punishment. If convicted, is sentenced to not less than 2 years in prison or more than 10 years in prison, and a potential fine not to exceed $10,000. I see there is a plea agreement in your case wherein you would plead guilty to that crime. State's recommending that the court consider the evidence today, convict you of the offense, sentence you to 10 years in prison, but suspend that sentence and place you on 10 years probation, community supervision, ordering you to pay fines, court costs, restitution, and reimbursement fees. Is that your understanding of the plea agreement? All right, Mr. Warrington, how do you plead to possession of a controlled substance, penalty group 1, greater than 1 gram, less than 4 grams? Are you pleading guilty to that crime because you are guilty of committing that crime? Anyone threat or pressure you to plead guilty? The court will accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection to stipulation of evidence as offered.
That is submitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
Judge, I don't normally do this, but this case is a unique case. Mr. Warrington is on stage 4 cancer and has come a long way since he bonded out on his recovery. He was, in this particular case, the reason I think we got this case was an overwhelming amount of support from his community where he is currently, both his church community, support community, that he's really made strides in his addiction, fighting that and getting his life turned around for his family. And so I think, even with the cancer and with where he is, that he's going to be successful on probation, because he really has turned things around in a way that I rarely see in my job.
It's good to hear. Sorry you're going through that, Mr. Warrington. Court has reviewed the evidence, finds that there is sufficient evidence to convict the defendant. Court follows the agreement state, convicts Kenneth Franklin Warrington, possession of a controlled substance, penalty group 1, greater than or equal to 1 gram, less than 4 grams. Court assesses punishment at 10 years confinement in Texas Department of Justice. Court suspends that sentence today, places the defendant on 10 years community supervision, orders him to pay a $2,000 fine, $180 restitution, $290 court costs, and $605 reimbursement fees. Mr. Warrington, you hereby remain into the custody of the probation department so they carry out the terms and conditions of the sentence. I'm gonna have you come forward to be presented with Deputy McLeish, and then the probation officers will tell you about the next steps. Yes. Those set for docket call days, my understanding that the state has requested more time to negotiate on the case, is that correct?
That's correct, Judge.
I of course reset Mr. Lowe for an additional docket call on November 9th.
And Judge, if we get a dispositive order in before then, the court.
Or yeah, court will entertain that prior to hearings. Nicole Sampson. All right, this is cause number CR 22-227. State versus Chacol. Is it Monique?
Okay.
Monet. Probably said that before, didn't it? Monet Sampson. Ms. Sampson, if you'll raise your right hand, I'm gonna place you oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth? So you can lower. All right, Ms. Sampson, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney? Feel like you've had enough time to talk about your case, you've had all of your legal questions answered, and that you understand everything that you've read and signed today on the agreement. Mr. Manning, do you believe that Ms. Sampson is competent? And if so, have you explained to her the advantages, disadvantages of her adjudication plea? And is she entering into this intentionally, knowingly, voluntarily?
Judge, she is competent. She has assisted in her defense. We've discussed several options for mitigation and defense. Second of all, she is entering this plea freely, knowingly, voluntarily, and I have discussed the benefits and detriments of for conviction.
Thank you, Mr. Manning. All right, Ms. Sampson, you are charged by indictment with a state jail felony offense of hindering secured creditors. It does carry a range of punishment if you were to be convicted and sentenced to not less than 6 months in prison or more than 2 years in prison, and also a potential fine not to exceed $10,000. Do you understand that the plea agreement in this case is that you would plead guilty to the crime in exchange for the state's recommendation that the court consider the evidence, not convict you, but rather place you on community supervision for a period of 2 years? In addition to that, you would have restitution in $2,545 plus court costs, reimbursement fees. And you understand, Ms. Sampson, that if the court follows this plea agreement, that if you violate any of the terms and conditions of your community supervision, or could conduct a hearing, hear the evidence, and if I find that you violated, or can do a multitude of things, including convicting you of the offense, revoking you all of the community supervision, and putting you in anywhere within that range of 6 months to 2 years. Understanding all that, do you still wish to go forward? Sampson, how do you plead to hindering secured creditors in an amount greater than $2,500 but less than $30? You're pleading guilty to that crime, but you are guilty of that crime. Has anyone threatened or forced or pressured you to plead guilty? Court accepts the defendant's plea of guilt. Mr. Manning, any objection to the commission's evidence?
No objection as of.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
The defense,
Nothing, Judge.
of course, going to review the stipulation. court having reviewed the evidence finds that there's sufficient evidence to convict Ms. Sampson of this offense. The court, however, follows the plea agreement and confirms a finding of guilt, places her on community supervision for 2 years, orders her to pay restitution in the amount of $2,545, reimbursement fees of $660, court costs of $290. Sampson, you hereby remanded to the custody of probation departments to carry out terms and conditions of the sentence. Have you come forward to be fingerprinted, and the probation officer will give you more information. Yes,
Judge Eric Sperling.
Berlin. This is call number CR 22-157, state versus Terry, Sterling.
Yes, Judge. Mr. Sperling and I have not had an opportunity yet to discuss, we were given some additional offers. Most recent by the state. I request this be set for additional docket call for us to discuss one of those offers, and decide what you'd like to do.
Objection to the state.
None, Your Honor.
All right, court's gonna set this for a final docket call. This next setting will be the third docket call, except for 3 pre-trial, 3 docket calls. So this will be the final docket call. Set that in November. We need to go out to November. Can we do it on October 12th? Any objection?
That'd be fine with me, Judge.
All right, we're gonna set this October 12th. 9 AM. So on that day, we'll either have a resolution, we'll set a trial.
Yes, Judge. Judge, and the last one I believe that I have
Here you go.
is Mr. McFarland. There's last one I believe has Mr. McFarland. If we have just a little bit more time on this case. I will. Sure.
Sure. So are you ready, Mr. Dunlap? Yes. Mr. Dunlap. This calls number CR 23-49, state of Texas versus John. All right, Mr. Dunlap, go raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, nothing but the truth, so help you God? Just lower your hand. Mr. Dunlap, are you a United States citizen who needs rights to speak English? Yes, sir. Have you ever been diagnosed with a mental health issue? And in this case, you're represented by your attorney, Mr. Jeff White. Will you please, Mr. White's representation, because glad we've had enough time to talk about this case, you've had all of your legal questions answered, and that you understand everything that you read and signed. Yes, sir. Mr. White, I believe Mr. Dunlap is competent. If so, have you explained his rights regarding this case?
I have explained his rights, Your Honor, and I believe he's competent to make the decisions that he's made today.
You believe that he's entering into this intentionally, knowingly, and voluntarily?
Yes, Your Honor.
Mr. Dunlap, you are charged by indictment with a third-degree felony offense of driving while intoxicated or that does carry a range of punishment if convicted and sentenced to not less than 2 years or more than 10 years confinement in prison and a potential fine not to exceed $10,000. I simply agree with your case that you're guilty to that crime. Exchange the state recommends that the court convict you of the offense, set your sentence today in 5 years in prison, but suspending that sentence for 5 years of immediate supervision. In addition, you would pay court costs, fines, restitution, and reimbursement. Is that your understanding of this? All right, then, Mr. Dunlap, how do you please drive an intoxicated burner? Guilty. Mr. Dunlap, are you pleading guilty to that crime because you are guilty of committing that crime? Yes. Has anyone threatened, forced, or pressured you to plead guilty? All right, 47. This time. Mr. White, any objections to stipulation of evidence?
No objection, Your Honor.
That is admitted, the court takes judicial notice of the defendant's. Anything further to say?
No, Your Honor.
Defense.
I think, Your Honor.
Do the stipulation. All right, upon reviewing the evidence, court finds that there's sufficient evidence to convict Mr. Dunlap of this offense. Court will follow the plea agreement. Court convicts John Casey Dunlap of driving while intoxicated, third or more, third-degree felony, assesses his punishment of 5 years confinement in Texas Department of Justice. Court suspends that sentence today, places Mr. Dunlap on 5 years of supervision. Orders him to pay a $2,500 fine, $290 in court costs, $60 in restitution, and $35 reimbursement fees. Mr. Dunlap, hereby remains in custody of the probation department so they can carry out the terms and conditions of this. That we come forward to be fingerprinted with deputy police. And report to the probation officer. And Mr. White. And Mr. And just so for the record, in this case, you had urged a motion to strike answer paragraphs. The court was prepared to rule on that today. It's my understanding that that motion is being withdrawn by virtue of this plea. Is that correct?
That's correct. We abandoned.
Thank you, Mr. White. Come on, board, Mr. White. Mr. Sanders, you're fine. Yes. Are y'all ready? All right, this is cause numbers in CR 23-119 and point state versus Jeremy Snelson, Docket call. Go ahead, Mr. Sanders.
Thank you, Judge. Judge, with Mr. Snelson's cases, he has two other co-defendants. Mr. White, Nolan White represents one of them. I was talking with him some this morning. I would ask if we could set it for another docket call so we could, he and I both could have some time to talk with Ms. Curry. I believe all the co-defendants are similarly situated, so we're trying to see what we can do to get everything resolved. And for Mr. Snelson, but also the co-defendants as well.
Mr. White represent both the other co-defendants.
No, he represents, I think, Mr. McClan. Yes. The other one may have a warrant out. McCoy, I believe, so I'm not sure what his situation is.
Said to October 24th, or I could do 7th or 9th.
November 9th might be best.
All right, court will set, Mr. Snelson, we're gonna do a final docket call on November 9th. Mr. Snelson, next time, make sure you leave early enough to be here at 9 o'clock, or you stay with me, understand traffic, but you understand it, you live there, you know. So course starts at 9 o'clock. All right. Yeah, that's fine. Practice game for. Simon Wilkes, CR 23-A2. All right, Mr. Wilkes, if you'll raise your right hand. Sir, do you swear that the testimony you give before today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand. All right, Mr. Wilkes, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
Yes.
Can you tell me about that?
Severe agoraphobia. So it's not comfortable to leave the house. Anxiety attacks, panic attacks, that's it.
Are you on medication for those or undergoing treatment?
Yes, sir.
Do you feel like those disorders are in any way affecting your ability to be here today, to understand what's going on?
No, sir.
Okay. In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White's representation?
Yes, I am.
Do you feel like you've had enough time to talk with him about your case, and that you've had all of your legal questions answered, and that you understand everything that you read and signed in your plea agreement?
Yes, sir.
Mr. White, do you believe that Mr. Wilkes is competent? Your Honor, I believe it's competent. He understands the procedure here today. He is for issues that I think where it was our representation of it. It's I'm satisfied. I'm satisfied with the understanding. He does what he's supposed to. The care is forever. But if he violates, and of course, it's about violence, there is the courts. Thank you, Mr. White. Mr. Wilkes, you heard all that, correct? Did you hear what Mr. White said?
Yes.
You understand it, correct?
Yes.
All right, Mr. Wilkes, you were originally indicted with a second-degree felony offense, aggravated assault with a deadly weapon. However, the court finds today that the plea agreement is for you to plead guilty to a lesser included offense of Class A misdemeanor deadly conduct, with the state's recommendation being that the court review the evidence, not convict you, but rather defer a finding of guilt and place you on community supervision for 2 years. In addition, you would have a $1,000 fine plus court costs and reimbursement. And the state would be dismissing the felony aggravated assault charge. Is that your understanding of the plea agreement?
Yes, sir.
All right, then Mr. Wilkes, understanding all of those things, how do you plead to the Class A misdemeanor deadly conduct.
Guilty, sir.
Are you pleading guilty to that crime because you are guilty of that crime?
Yes, sir.
All right, court accepts the defendant's plea of guilt. Mr. White, any objections to the stipulation of evidence? All right, stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor.
from the defense, Mr. White? No. All right, of course, we review the stipulation. All right, court reviewing the evidence finds that there's sufficient evidence to convict Mr. Wilkes. Or will follow the agreement today. The court defers the finding of guilt on the Class A misdemeanor offense of deadly conduct, or places Mr. Wilkes on community supervision for a period of 2 years, or also assesses a $1,000 fine for a cost of $270 for the use of 35. Mr. Wilkes hereby remains in custody of the probation department, so they can carry out the terms and conditions of the sentence. Then he come forward to be fingerprinted, and then the probation officer to give you confirmation.
Thank you, sir.
Could we call Ms. Jacobs, please? Ms. Jacobs, if you come forward. This cause number CR 23-100. Say versus Tracy Lane Jacobs, pretrial. Your Honor, this, I don't, it's the same. I don't anticipate being. Pretrial order, no. That it got involved. I believe state. And our side are pretty much in agreement with this case resolved. There is an issue regarding restitution. And there's considerable amount of footage from closer television that I'm gonna have to come up with you. District Attorney Office, but myself was trying to download that course. And or if DA understand the stuff is taking long. They would like to bring your city in 2 hours, not going to stop them. Then I would you. I believe the state is getting me. There's understands I have no questions about certain transactions. You know, there you have the reason I talk for that is this could be a long process, but I would kind of think that most of the time. We'll say 30 days, you kind of status of that. I don't say status, but I said I'm very strong. Agree, rest of what was going to happen, it's just the rest of the game. And I will go on that as well. It's not like we're way off, you know, together. It's just a matter of figuring out exactly. We're about to setting it for additional pretrial on November 9th. Your Honor, that. Thank you. All right, court sets Ms. Jacobs for additional pretrial November 9th. It'll be at 9 a.m. Brandon. Mr. McClanahan, CR 23-109-10. All right, Mr. McClanahan, some withdrawal also. Your Honor, we don't have any contested matters. That's is he co-defendant, Mr. Snelson? I think I set Mr. Snell's final docket call on November 9th. Mr. Sanders referenced, possibly trying to discuss the case with you, maybe it's kind of below resolution of all of these code of things, you're gonna be set at the same time. That would be fun. We did talk about, I believe the code of minutes were all various. So I'll just set him for a final docket call November 9th. Maybe I'll think worked out. Yeah, maybe. Okay. Yes. Mr. McCann, I do show that you're a little bit delinquent on your pre-trial release money, not much, like $30. Okay, thank you, I appreciate it. Good. All right, Court finds some scouting set for docket call today, after bench consultation with the state defense. Court's going to grant the request for additional time for some defensive, investigation. Court's going to reset this, Tuesday, November. Docket call. 9 a.m. Okay. Yeah. Yes. My son is. All right, this is cause number CR 22-335 and CR 23-105. State versus Penny, William McFarland. Mr. McFarland, if you'll raise your right hand, I'll place you on oath. Sir, do you swear that the testimony you give to the court today is the truth, the whole truth, nothing but the truth? So help me God.
And Judge, if I may, Mr. McFarland is hard of hearing, and I think part of what led to some of the confusion in our last court setting was he misheard some of what was going on, and so I've told him that at any point in time, if he's unable to hear or misunderstand something, to tap me on the shoulder, and we'll go back over that again.
Okay, very well. All right, I'll try to speak up. Mr. McFarland, are you a United States citizen who reads, writes, and speaks English? You have to say yes or no.
Yes.
So she can type it in. Say again.
Yes,
And have you ever been diagnosed with a mental condition?
no,
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's representation?
yes,
You feel like you've had enough time to talk to him about your cases and you've had all of your legal questions answered and you understand everything that you've read and signed in your plea agreement?
yes, yes,
Mr. Manning, to believe Mr. McFarland to be competent.
Do Judge,
You've explained to him his rights as a routine in his cases.
I have,
You believe that he's entering into these intentionally knowing voluntary.
I do.
All right, Mr. McFarland, you are charged by indictment in CR 22-335. With the second degree felony offense of aggravated assault with a deadly weapon. I see though that the plea agreement in this case is that you would plead guilty to a lesser offense of class A misdemeanor deadly conduct. With a plea agreement that upon being found guilty, that you would be punished with 1 year in the county jail for suspending that and placing you on probation for 2 years, plus fines, court costs, and reimbursements. In addition, it appears that the state would be dismissing a tampering or fabricating physical evidence, a deadly conduct, and a violation of a protective order alleged to occur on or about July 5th, 2023 in Banting County, which has not been received by the DA's office. Portion of this plea agreement is that you would also be ordered to have no contact with the victim in this case. Is that your understanding of the case, what you're asking the court to approve?
yes,
And Judge, if I may, while it's not on the paperwork, Mr. McFarland lives next to the alleged victim complaint witness in this case, and does have property there. We are requesting that within 7 days' time of today, that he go out there under supervision of the command facility constable to get that property. I've spoken to the state, they're not opposed to that. But he does have property such as a tractor and other farming implements there on the property that will have to be.
Okay. All right, Mr. McFarland, the range of punishment for a class A misdemeanor deadly conduct is confinement in the county jail for a period not to exceed 365 days or a fine not to exceed $4,000. How do you plead to deadly conduct in class A misdemeanor?
guilty, sir,
Are you pleading guilty to that crime because you are guilty of committing that crime? Are you pleading guilty because you are pleading that you are guilty of this crime? You're not just pleading guilty so that you can get a certain plea bargain, right?
yes,
All right, court will accept the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection to the stipulation of evidence as offered.
State's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. I'm not sure if I asked you, Mr. Manning, you do believe that Mr. McFarland's competent in entering into this intentionally, knowingly, and voluntarily, correct?
Judge did ask, and I do believe he is competent. We've had many opportunities to discuss many aspects of his case as well as potential defenses. He has maintained his innocence on certain offenses, certain elements of offenses throughout the entirety of my representation of him. And so this comports with the facts and my client's belief of what happened on that date in question.
Thank you, sir. All right. Court has reviewed the stipulation of evidence. Court finds that there is sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement. The court convicts Benny William McFarland of deadly conduct, class A misdemeanor, assesses his punishment at 1 year confinement in the county jail, suspends that and places him on community supervision for 2 years, orders him to pay a $500 fine, $270 in court costs, $535 in reimbursement fees. Court dismisses under section 1245, tampering with physical evidence, DA 2022-0004. And deadly conduct, DA 2021-860, and a violation of executive order alleged to have occurred on or about July 5th, 2023 in Bainton County. As a condition of community supervision, Mr. McFarland is ordered to not have any contact with the victim in this case. I'm assuming that that person is identified in the document. And that'll be provided to the information department. All right, Mr. McFarland, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Please come forward to be fingerprinted with Deputy Lee. Probation officers will tell you what's next.
And Judge, just one further matter, I believe, I didn't hear it in the sentence, but CR 23-105, there was also a dismissal that was filed, the straight dismissal was filed with that.
Yes, court has viewed the motion to dismiss. The court has granted the same in CR 23-10. It's the announcement, Officer Lambert.
Judge, I believe it's state.
Yes, I don't know. Sitting there.
For the record, cause number CR 23-56. State has declared a motion to dismiss in the interest of justice. Or granting that motion. Dismiss. And I think that concludes this. Docket, court's going to adjourn and stand in recess until 1:30.
No, thanks.